Welcome to the deep dive. Today, our mission is to explore a fundamental shift happening in the legal world.
Yeah, and frankly, in any industry where the stakes are just, incredibly high.
Right, exactly. We are looking at the critical transition from reactive to proactive risk management.
It's a huge topic.
It really is. And the insights we're unpacking today, they are rooted in the principles of modern legal project management. So, heavily influenced by experts like Nicolene Shulman Liu and the frameworks from the International Institute of Legal Project Management.
Right, which are just fantastic resources.
Totally. And whether you are a legal professional or someone who runs a business, or if you just have to manage complex projects in general, the goal today is to equip you with the mental frameworks to anticipate what could go wrong, before it actually does.
Yeah, because it is a totally different way of looking at a project. You are shifting from just doing the technical work to actually safeguarding the entire environment where that work happens.
Which, that brings us to a story that perfectly captures why this is so vital.
Oh, the property developer story.
Yes. So imagine a highly competent commercial property firm, right? They are acting for a developer on a massive mixed-use site acquisition. I'm talking millions of dollars on the line.
High pressure.
Very high pressure. But the lawyers, they do everything right. The title is completely clear. The sale agreement is drafted flawlessly. The transfer is registered exactly on time.
So on paper, high fives all around, right?
Exactly. Total success, pop the champagne. But 3 months later, absolute disaster strikes.
Yeah, this is where it gets painful.
Right. The developer discovers that a heritage designation process had been initiated on a portion of the property literally before the sale even went through.
Wow.
Yeah, and now this designation halts all of their development potential. The whole project just grinds to a halt, the value of the land plummets, and, well, naturally, massive litigation follows.
Right. And, the mechanism of failure here is what makes this case so important to study.
How so?
Well, if you look closely at the postmortem of that deal, no one missed a strictly legal step. Like the lawyers didn't misinterpret a statute.
Yeah.
They didn't draft a sloppy liability clause.
Wait, okay, for those of us not buying skyscrapers every day, the conveyancing due diligence is basically like the deep background check you run on a property before buying it, right?
Did they just skip it?
That is a great way to put it. But
Yeah.
no, they didn't skip it. They executed the standard background check perfectly.
So what happened?
What they missed was a risk sitting just slightly outside the conventional scope of that specific check. It was a municipal notice about a potential heritage site.
Oh, wow.
Yeah, a regulatory process that had started but just hadn't concluded yet. The seller didn't flag it, and the lawyers weren't looking for it because, well, it just wasn't a standard box to check on their form.
It's like an airline executing a technically perfect takeoff and flight, only to realize right as they're descending that they forgot to check if the destination airport was even open.
Oh, that is a terrifying analogy. Right. The flying was absolutely flawless, but the planning was fatal.
It's terrifying.
Yeah.
But it's incredibly accurate for the structural vulnerability of reactive legal practice. I mean, the
Yeah.
lawyers were looking for established legal roadblocks, not vulnerabilities in the delivery of the project itself.
Yeah.
And this exposes the blind spot we see across the entire profession. Because to understand how a massive error slips past highly trained, incredibly smart professionals, well, you have to look at the psychology of how lawyers are trained.
Okay, the blind spot. Let's get into that. What exactly are we looking at here?
Well, they are taught to manage one very specific type of risk, and they basically completely ignore another.
So what are the two types of risk?
In the legal profession, lawyers are traditionally exceptional at identifying what we call legal risk.
Okay.
This is your regulatory exposure, your contractual liability, the probability of losing a litigation case. The entire structure of law school is basically built around reading historical case law to spot legal risk.
Right, because that's what you pay them for, right? You ask, can they sue us? And the lawyer tells you yes or no.
Exactly. It is the core competency of the profession. But there is a second category, and this is where that blind spot lives. We call it project risk.
Project risk.
Yeah. Project risk isn't about the client's legal exposure. It's about the risks that prevent the legal matter itself from being delivered successfully.
Ah, I see.
And because law school focuses on the brilliance of the individual legal mind, it rarely teaches systems thinking. So project risk just goes entirely unmanaged.
Okay, let me challenge you on this for a second, though. If I am hiring a law firm, I am paying for their legal brain, not like their filing system.
Sure, yeah.
So if legal risk is, will we win this lawsuit, is project risk just a fancy way of saying, are we organized enough to file the paperwork on time? Isn't that just admin work? I can see a lot of senior partners rolling their eyes at the idea of managing admin.
I hear that pushback constantly, especially from senior partners. I really do. But calling it just admin fundamentally misunderstands the catastrophic impact it has on the client.
Okay, give me an example.
Let me walk you through some scenarios from the source material that show how mismanaging the project directly creates legal and financial failure.
Okay, let's hear it.
Imagine a perfectly drafted contract. I mean, the legal risk is managed brilliantly, but it is delivered to the client 2 weeks late because a key team member was unavailable and, well, no backup had been arranged.
Oh, yikes.
Right. That delay might cost the client the entire deal. The brilliance of the contract is totally useless if it arrives after the deadline.
That makes total sense. The delivery mechanism failed, the flying was perfect, the airport was closed.
Exactly. Let's look at a due diligence process, much like our heritage site example. Imagine a team misses a massive corporate liability. They didn't miss it because they don't know the law.
Right.
They missed it because the data room, the digital vault, where all the documents are stored, was totally disorganized.
Oh, I've been in those data rooms. It is a nightmare.
It is. Crucial documents were uploaded late by the other side, right during a week when the legal team was completely consumed by a different, unrelated crisis. The chaos of the environment essentially blinded the lawyer to the legal risk.
So the failure of the project basically causes the failure of the law.
That's exactly it. Or consider a settlement negotiation that completely collapses. The lawyer negotiated a brilliant dollar amount, but they didn't factor the insurance company's internal approval timeline into the schedule.
Oh, so they just ran out of time.
Yep. The deadline passes, the offer expires, and suddenly they are going to court. The legal strategy was perfect, but the project management was non-existent.
Which means the firm is bleeding money too, right? Because if a case blows up due to disorganization, the firm probably has to spend double the hours they quoted just trying to fix a mess that should have been anticipated.
Oh, absolutely.
And you can't exactly bill a client for your own chaos.
You absolutely cannot. The aggregate cost of getting this wrong is staggering, but it's a quiet, accumulating cost. It's not always a headline-grabbing lawsuit,
Right, it's just a slow bleed.
Yeah, it is massive write-offs on cost overruns, which slowly erodes a firm's profitability. It's avoidable team pressure that leads to severe burnout. And ultimately, it destroys client trust.
So once you realize that project risk is this silent margin killer, you need a map of where these risks actually hide. Because you can't just tell a team of lawyers, hey, watch out for bad admin. That isn't really actionable.
No, it's not. You need a structured taxonomy.
Okay, so what does that look like?
In modern legal project management, we break this down into 5 specific categories of legal risk that have to be managed actively.
Let's hear them.
We've got client risk, process risk, technology risk, regulatory risk, and resource risk.
Okay, let's unpack these, because if you want to catch things early, you really have to know where to look. I want to start with the first one, client risk, because I find this fascinating.
That's a big one.
Yeah, if you've ever managed a team, you just assume the danger is the opponent or the changing market or an angry judge. But you're saying the biggest risk to a project is often the people writing the checks.
Yeah, the clients themselves are a massive source of unpredictability. Client risk covers their capacity, their responsiveness, undisclosed conflicts of interest, and their financial position.
Okay.
But the absolute most common failure point is decision-making authority.
What do you mean?
Well, you can have a perfectly sound legal strategy, right? But if your client is a corporation and the board of directors is completely misaligned with the CEO on what they actually want to achieve, well, your project is going to derail at the 11th hour.
Wow. Yeah. So you could draft the perfect merger agreement, but if the client hasn't actually figured out who internally has the legal authority to sign the document, you just missed the closing window.
Exactly.
You are essentially building a house on a foundation that the client hasn't even finished pouring.
That happens way more often than anyone wants to admit.
I bet.
Then you move into the second category, which is process risk. This is about the mechanics of the matter itself, poor matter planning, terrible document management, and, missing deadlines.
And what's the biggest vulnerability there?
A massive vulnerability here is knowledge transfer.
Like what happens when the team changes mid-case?
That is the nightmare scenario. If the entire strategy of a complex, Multi-year litigation is held exclusively in one senior partner's head, and that partner goes on sudden medical leave.
Oh boy.
Yeah, the project is in severe danger. A lack of documented process means the incoming team is basically flying blind.
Which naturally brings us to technology risk. And I feel like the immediate assumption is hackers, cybersecurity, data breaches, which are obviously terrifying.
They are, and data security is a huge component of it. But technology risk is also far more mundane and, honestly, equally destructive.
Like what?
It is critical system failures at the worst possible time. Imagine your firm's document review platform crashing at 11:59 p.m. the night before a major court filing.
Oh, that's nightmare fuel. Or even just using outdated software, right? If the opposing counsel has AI-driven contract review tools that process 1,000 pages an hour, and your team is using highlighters and sticky notes,
Right.
your capacity is severely limited, you are outmatched technologically, which becomes a project risk.
Exactly, which is why you have to audit your tools before you begin. And then the fourth category is regulatory risk, which brings us right back to our property developers in the opening story.
Right, this is where the environment around the project shifts. So changes to legislation, unexpected regulatory timelines, or like third-party approvals.
Think about how many legal matters require an external body to say yes before you can proceed.
Like an antitrust review.
Yes, or a municipal zoning board or a heritage site committee. If you don't map out the timeline for those external approvals, well, you are entirely at their mercy.
And finally, the fifth category, resource risk. This is basically the human element on your own side of the table, isn't it?
It is. It's your team's availability, their expertise gaps, and workload conflicts.
Right.
You might have the best lead lawyer in the country assigned to your case. But if they are suddenly pulled into a bigger, more lucrative crisis for another client, well, who is doing your work?
Good question.
If there are no cover arrangements in place, the resource risk just became a project failure.
Okay, so we have this map. We know the 5 categories where things go wrong: client, process, technology, regulatory, and resource.
Yes.
But knowing the categories is basically useless unless you have a structured way to actually extract these risks from your team's brains before the crisis hits. I mean, we need a way to get the information out in the open.
You need an intervention mechanism.
Right. And there is a tool of this that I find incredibly compelling, mostly because it wasn't even invented for lawyers.
Oh, it's brilliant.
It's borrowed directly from manufacturing and quality management. It's called the fishbone diagram or the Ishikawa diagram. And apparently it translates perfectly into legal brainstorming.
It translates beautifully because it forces visual, structured thinking.
Okay, break it down for us.
The fishbone diagram is designed to identify the root causes of potential problems before they occur. It is the difference between a doctor treating your sudden heart attack in the emergency room versus a doctor looking at your lifestyle habits 5 years earlier to prevent the heart attack entirely.
I love that. So how do we actually draw this out? How do we apply a manufacturing tool to a legal matter?
Well, it takes its name from its shape. You start by drawing a long horizontal line across a whiteboard that's the spine of the fish.
Okay, got it.
At the far right end, you draw the head, which is the specific problem you are analyzing. Step 1 of this 5-step process is crucial. Define the risk clearly.
So you wouldn't just write something like, the matter might go poorly?
No, absolutely not. That is way too vague to be actionable. You need highly specific, outcome-based language.
Like what?
You write something like, the transaction cannot close by the agreed long stop date.
Meaning the drop-dead date where everyone is legally allowed to walk away from the deal if it isn't finished?
Yes, exactly. Or, if it is litigation, you might write, the hearing may be postponed due to incomplete discovery.
Like when one side hasn't handed over all their emails and documents yet.
Precisely.
Huh.
The specificity in the head of the fish basically determines the quality of the entire exercise.
Okay, so we have the head. What's step 2?
Once you have the head, you move to step 2. Identify the key categories. These are the bones extending diagonally off the spine. And here you just use the categories we just discussed.
Ah, okay.
Yeah, you draw a bone for client, one for process, technology, regulatory, and resource.
Although I noticed in the source material that if it's a transactional matter, like a merger or an acquisition, the recommendation is to actually add a 6th bone, counterparty factors.
It's to finish on time, and you are totally vulnerable if their management team changes mid-deal.
Makes sense.
So those are your bones. Step 3 is where the real value is generated, and that's brainstorm potential causes.
And this has to be a team sport, right?
It is entirely dependent on diverse perspectives.
Yeah.
You get the partners, the associates, the paralegals, and ideally even the client in a room.
Wow, the client too.
Ideally, yeah.
Yeah.
You look at the client bone and ask, what could go wrong here? And a paralegal who actually handles the day-to-day emails might speak up and say, well, the client hasn't confirmed their internal sign-off authority, so instructions might be delayed by a week.
Oh, that's such a good catch.
Right. Or, under regulatory,
Yeah.
an associate notes a pending change to competition laws that no one else is tracking.
Yeah.
You are basically making the invisible visible.
Okay, I have to play devil's advocate here for a second.
Go for it.
I can hear some lawyers listening to this, and they're just groaning right now. They are thinking, I bill in 6-minute increments. I am under immense pressure. I do not have time to draw fish on a whiteboard for every routine contract I review.
I know.
Isn't this kind of over-engineering a process that usually works fine?
That pushback is exactly why Step 4 is the most important part of the entire framework, which is assess and prioritize. You do not treat every brainstormed risk equally. That would be a massive waste of time. Instead, you plot them on a simple matrix of likelihood versus severity.
Okay, so you are filtering them.
You're filtering reality. If a risk has a high likelihood of happening and a high impact if it does, well, it demands active mitigation.
Right.
But what if a risk is low impact and low likelihood? What if a junior associate worries that, I don't know, a meteor might hit the courthouse?
Yeah, you don't build a massive action plan for a meteor strike.
You don't. You just monitor the low priority risks or you accept them. Doing this structured thinking doesn't waste time. It actually saves countless hours of firefighting later by focusing your energy only on the threats that matter.
That makes a lot of sense.
Which leads directly to Step 5. Develop mitigation strategies.
Right. This is where the theoretical becomes practical.
Yes. For your high priority risks, you don't just write down, we will keep an eye on it.
That never works.
Never. You assign a specific, named action to an accountable person with a deadline.
So instead of saying, we need to make sure the client can sign, you say, Sarah will confirm the client's internal sign-off chain by Friday at noon.
Exactly. Not a general intention, a concrete task.
Yeah.
That is how you diffuse the risk before it detonates.
Okay, so we've got this great brainstorming tool, but, to ensure this isn't just a one-off gimmick that a team tries at an offsite retreat and then immediately forgets, it needs to become a systematic habit. It really has to be baked into the firm's DNA.
And this is where broader frameworks come into play, like the methodology from the International Institute of Legal Project Management.
Right.
They embed proactive risk management into everyday practice using a very simple 4-step continuous loop. Plan, do, check, act.
Plan, do, check, act. It's almost like a heartbeat for the project.
It is the rhythm of execution.
Yeah.
And it is vital to understand that this isn't just academic theory devised in a vacuum. These approaches are championed by people like Nicolene Shulman-Liu, who draws on over 2 decades of real-world legal experience in complex transactions and intense litigation. I mean, she knows what actually works in the trenches when the pressure's on.
Absolutely.
Risk identification using the fishbone gets built into the plan phase. But you don't just stop there. You build review checkpoints into the check phase of every single matter to see if new risks have emerged.
For those listening who might not have time to do a full fishbone diagram today, there's a fantastic minimum viable risk review checklist in the source material.
Oh, yes, that is golden.
I want to share this because it's something you can literally use on your very next project, even if you aren't a lawyer.
I think everyone should have this taped to their monitor.
Seriously. So before starting the actual work, confirm these 4 things. 1, identify all stakeholders, especially anyone with blocking rights who can veto the project. 2, confirm exactly who the client's internal decision maker is. 3, ensure you have cover for key team members in case someone gets sick or quits. And 4, map the timeline backward from the final deliverable date.
That 4th point, mapping backward, is uniquely powerful.
Why is that?
Well, when you plan forward, you tend to be overly optimistic. But when you map backward from a hard deadline, it immediately exposes the dependencies.
Oh, I see.
You realize, wait, to file this brief by Friday, we need the final document by Wednesday, which means the client has to approve it Tuesday, which means we have to finish drafting by Monday.
Right. It kind of forces you to face the music.
It shifts your brain entirely out of reactive mode
Right.
and forces you to confront the reality of the schedule.
So what is the ultimate payoff for a professional who actually takes the time to learn this? I mean, we see certifications for this being offered globally and through platforms in Africa. Why go through the effort to just rewire how you work?
The professional advantage is transformative. Lawyers, or frankly any professionals who master this, stop being mere documenters. They stop just papering over decisions that have already been made, and they elevate themselves into highly valued strategic advisors.
Because they are looking around corners for the client. They are seeing the heritage site designation before the land is even purchased.
They are helping clients navigate uncertainty. And if you identify a regulatory roadblock before a deal is signed, and you structure the transaction to avoid it entirely, you are delivering infinitely more value than the lawyer who just reacts to the litigation after the deal collapses.
Definitely.
This proactive approach builds incredibly deep client trust, primarily because it eliminates the constant erosion of trust that comes from reactive firefighting.
Yeah, nobody likes getting a frantic phone call from their lawyer on a Friday afternoon asking for a document that was needed 3 weeks ago.
Nobody. Proactive communication changes the entire dynamic of the professional relationship. You become a partner in their success rather than just an expense on their balance sheet.
So, to bring this all together for you listening, we started today looking at a disastrous oversight on a heritage site where the law was followed flawlessly, but the project planning was fatal.
A painful lesson.
Truly. We discovered the vital difference between legal risk managing the actual law and project risk managing the delivery of the law.
Right.
We unpack the 5 categories where those risks hide: client, process, technology, regulatory, and resource. And we learned how to dissect them using the fishbone diagram, moving from a vague sense of dread to highly specific, assigned mitigation tasks within the plan, do, check, act framework.
It really is a complete paradigm shift in how high-stakes work is managed.
It is, and the direct application for you is huge.
Yeah.
Applying this mindset, whether you are prepping for a massive legal case or organizing a routine corporate meeting or managing a sprawling team project, it turns you into the person who anticipates uncertainty rather than the person who's just constantly reacting to crises.
Exactly.
To stop putting out fires, and you start fireproofing the building.
And, as we look at how this shift is taking hold, it raises a rather profound question.
Oh.
Yeah, something I think everyone should ponder as they look at the future of the professional services industry. If project risk is increasingly recognized as the primary reason matters fail or run wildly over budget,
Right.
are we approaching a future where managing project risk is no longer just a smart business strategy, but a strict ethical and fiduciary duty?
Wow.
Will we reach a point where clients demand to see a firm's fishbone diagrams before they even sign an engagement letter?
Show me your bones. I like that. Definitely something for all of us to think about next time we sign an engagement letter. Thanks for taking the deep dive with us.